Thank you for joining us today for the final session of Venable's virtual ad law symposium. We look forward to when we can do these in person. It's a lot more fun to be able to see you all face to face and break bread. Our symposium this year, as in past years, covers current trends, topics, and developments in the advertising industry and the legal aspects of that. Our sessions earlier this week focused on NAD regulation and privacy developments and enforcement trends. And in today's session, we're fortunate to have Daniel Kaufman, who is the acting director of the FTC's Bureau of Consumer Protection, to discuss FTC enforcement priorities in the new administration. Daniel serves as the acting director of the Bureau of Consumer Protection. Previously, he was the deputy director of the Bureau of Consumer Protection. He served in that position for quite some time. Before that, he was the chief of staff to former chair Deborah Majoris, and he was a staff lawyer bringing advertising cases a long time ago. Today's session is eligible for CLE in certain jurisdictions. Later on, I will give the code some of you may need to get that CLE. There is a function, Q&A function that you can use to submit questions. I can't promise you we're going to get to them or that Daniel will be able to answer them, but we'll do our best. And with that, I'll get started. So Daniel, first, I just wanted to say thank you for making the time to speak with us today. I fully appreciate how busy you are, and we really are grateful for your sharing your time. The focus today is, what's new? We have a new administration. We have a new acting chair. You're new in your job. So we thought it would be great to hear from you about changes in priorities at the Bureau of Consumer Protection and the FTC. From the Joe Simons, Andrew Smith era to the Slaughter Kaufman era. So if you could give us a little sense of sort of how things are changing and what those new priorities might be, that would be wonderful. I know the audience is very interested in hearing from you on this.
Len, and I got to tell you how odd it is to hear it referred to as the sort of Slaughter Kaufman era. So I just, after 22 years at the agency, I was never really planning for my name to be in the title there, and it is acting, to be clear, very much acting. So I appreciate the question. I'm glad to be here. I really enjoy these opportunities to talk about what we're doing. I've been at the FTC 22 years because I care deeply, and the work we do excites me a great deal. I do want to give my usual disclaimer here. The comments are my own, do not necessarily reflect the views of the commission or any commissioner. So I believe that gives me leeway to say whatever I want to. But talking about, so what are the priorities going forward? How do things differ? The first thing, and there are really two big substantive priorities that we're talking about right now, and some sort of more structural, broad ones. So the big first one, not surprising, it's COVID. And COVID issues are just a huge issue in BCP. I will say about 13, 14 months ago, it became all hands on deck in the Bureau of Consumer Protection on COVID. And I'm really incredibly proud of the work that we've accomplished in the last year, addressing some real challenging, thorny issues under difficult circumstances. So, just to give a little background on it, by February of last year, our Division of Consumer and Business Education was already out there issuing consumer education to beware of the scams that we know always proliferate when we have these sorts of health issues. Of course, at that point, we didn't realize the extent of it, but we were out there early with consumer education. That continued throughout and continues to this day. Now we're dealing with vaccine scams, but there's been an extensive push on education, on outreach, on talking to the media, and a heavy amount of enforcement. We were able to get, I think it's 400 entities or companies to take down really bad deceptive claims on their websites very quickly, using warning letters. We had incredible success getting bad claims taken off the internet very quickly. And we've also brought a number of enforcement actions. We've brought about a dozen enforcement actions challenging deceptive product claims, mail order violations in terms of companies that were promising, it could have been different masks, non-delivery. So there's been an aggressive amount of law enforcement that we've done as well, specifically on COVID issues. And also there are cases we've been bringing and issues we've been addressing that are starting to deal with sort of the broader ramifications of COVID. We know that everyone, obviously we're on platforms talking remotely. Zoom has been an incredibly important tool, and we brought a case against Zoom last year for misrepresenting things such as the level of encryption that they were offering. So virtually every division in BCP and every region has been actively involved in COVID issues, and this is going to continue. Excuse me. Even as people are getting vaccinated, it's exciting. Change is in the air, but the ramifications are going to exist. The impact of this pandemic on the American public, on people's financial stability, on their savings, on their ability to pay their rent and their mortgage. We're going to be feeling this for quite a while. And, we are very concerned, particularly about the impact on people of color. We know they've had a disproportionate impact on the pandemic and the ramifications. So there'll be a lot more COVID work that we're doing down the road, but it probably will take a bit of a different form. I will say at the end of last year, Congress did give the FTC civil penalty authority, which we will be using to go after deceptive practices. I think the phrase was associated with COVID-19. So you will be seeing cases coming out the door on specifically COVID issues using this new authority. We're also doing hiring now in order to make sure we have everyone prepared to do this work. And we're going to bring more enforcement. We'll have continued cases involving, some of the core advertising issues, prevention, cures, but we're also going to look at really the economic insecurity issues and making sure that we're doing work probably analogous to what we saw in 2008. The huge economic hit that took people, and we know there will be a lot of entities out there trying to take advantage of the economic insecurity. Whether it's business opportunity issues, investment scams, pyramids for people looking to supplement their income. There will be debt relief issues, eviction relief, mortgage foreclosure rescue issues, imposter scams, and vaccine issues. So I think we're going to see a ripe amount of COVID work. But I want to just emphasize, we are really looking at COVID through the broader lens now. It's different than just take the supplement to prevent COVID. Much broader, and we're definitely looking at it from a broad lens in terms of the impact on the economy generally. So COVID, huge issue. It will remain a huge issue, and we're really excited to continue working on that. The second big priority substantively, issues involving social justice and racial equity. In the Bureau, and in the agency overall, we want to make sure we are serving all communities, including those who may be less likely to report fraud to the government. So we'll do this through continued outreach, working with partners to determine, what are the problems that are affecting poor communities? What are problems affecting the elderly and communities of color? It's a very important issue to us. We just launched a few weeks ago something called the Community Advocate Center, and we're working with community legal aid organizations to expand our outreach to lower income communities to encourage them to report fraud, because we do know there is underreporting in those communities, and provide advice to help them recover. So 30 organizations have signed up so far. It's a really interesting program that we're very excited about. Also, our Bureau of Economics has done some really valuable research on how fraud affects different communities, who is losing money, and who does and doesn't complain. And we can use that data and continue to use that data to drive our research and targeting. So there's the broad issue. It's outreach, making sure our work is impacting all communities, but we're also looking for discriminatory impacts in advertising, in data collection, in marketing. The most obvious example is ECOA. Last year we did settle, I think it was our first case ECOA case involving a car dealership. But we want to make sure we're understanding and looking at how algorithms are driving credit and other decisions that can have a disparate impact on communities of color. So in a lot of our investigations, we're going to be asking ourselves these questions. How is what we're looking at contributing to issues involving inequity? We have, and hopefully I'll talk about it a little more later. We've got a workshop later this month on dark patterns. That's one of the issues that we'll be talking about. What's the impact on different communities? And it's also an issue we're exploring in our current study that we're doing involving social media platforms. It's also a core part of our privacy program as well. And I'm sure we'll be talking about privacy later, because it's pretty rare that I speak at any of these events without talking a lot about sort of what Privacy 2021 looks like. So those are sort of, to me, the two big substantive issues that we will be emphasizing. Obviously, there's an enormous amount of other work that will continue at the FTC. But on the more broad perspective, certainly the acting chairwoman has made it clear that seeking aggressive remedies is very important to her. Making sure that we are getting notice in cases whenever it is appropriate, and there's I think a broader universe of cases where we will be seeking notice, and also making sure we're using every tool in our toolbox. There are times where we might not double plead an allegation. Maybe Section 5 covers it well. Why bother using this other statute? I think we're going to see a lot more instances where we're using Section 5 as well as whatever the other tool might be, an emphasis on making sure we're sort of using the tools in our toolkit and using them as much as possible. So I would say, again, the Kaufman BCP for as long as it may exist, and I think whoever my predecessor will do will keeping the seat warm for somebody, and I'm making sure the Bureau is in great shape for whoever does take over after me.
Thanks, Daniel. That was a great answer. Just wanted to ask you a couple of quick questions following up on some of what you said. The FTC's use of warning letters in response to the COVID crisis was something I had never seen before. That vibrant or vigorous a use. Do you think that's something that might continue? As I know at different times the agencies thought about enforcement-light approaches, how to maximize the prophylactic things that they can do to sort of stop harm wisely, as opposed to sort of playing whack-a-mole and bringing one case that consumes a lot of resources. Do you think that warning letter approach may have longer lasting effects? Because it obviously was successful in knocking a lot of claims off the shelf.
Yeah, it was really successful. I'm very proud of that work, but it's not enforcement. It's not enforcement in the sense that we're not in court and we're not creating case law and we're not getting money back. And those are really important things to do. So I think there's a time and place for warning letters when they're suitable, and it will remain a tool that we use in some cases. But I do think what we were experiencing starting March of last year was just uniquely different. And we weren't barely able to go to courts to do anything. So in some ways, it was like the best tool, the available tool. And I will say a lot of the warning letter recipients, they weren't enormous companies. We were able to bring the claims down really quickly. So it will remain a tool, but I don't think you're going to see sort of nearly as extensive a use of warning letters as you saw for the past year.
That makes sense. On the civil penalty authority for COVID-related cases, what kind of cases are you thinking about there when you think about COVID-related cases? Are these, cure cases, or are these sort of the more broad economic impact cases that are related to COVID, but not related specifically to the disease?
So I would say so far the cases we're looking at, and it's obviously authority that we got recently, so we're still sort of analyzing the extent of our authority and how far we can take it. But certainly the cases we're looking at right now have a very, very close COVID nexus. It could be a cure issue, it could be a prevention issue, it could be, we've read a number of cases involving masks, things of that ilk. And I think time will tell in terms of how broad we can go using this authority. But if we can go broad, we will go broad. That's for sure.
Great. Thank you. And you've probably alluded to this a little bit on the social justice issue, but I want to make sure there's not something else. So on the antitrust side of the FTC, Chairwoman Slaughter has announced the plan to really rethink how the agency does pharmaceutical mergers, which has consumed an enormous amount of the competition mission. Thoughts of sort of rethinking the FTC's approach to other issues on the BCP side? I think obviously the social justice and racial equality is a new area of emphasis, but I don't know if there's anything else that comes to mind there, that sort of really rethinking the legal approach, the economic approach, the way the agency would bring cases, all those types of things that are clearly being rethought on the pharmaceutical merger side.
So I would say sort of two things jump at me. One is the remedial approach. What are the remedies that we're seeking? And we've seen that recently in some recently announced cases on the privacy side. We brought a case against the company Everalbum involving facial recognition technology. And we required the company to destroy any algorithms that they were able to generate based on the misuse of customers' photos. So that was sort of a novel remedy theory there. In other cases like SkyMed and Flow, again, privacy data security cases, we've required companies to send notices to their customers about the conduct. And again, that is not relief that we've traditionally done in the privacy data security world. I mean, maybe some instances, I don't want to overstate it. So remedies is definitely an area where we're looking much more broadly. Another area that I would emphasize, because it has a really broad impact on us. So I mentioned, the the dark patterns workshop that we're doing at the FTC. Next 2 weeks from now, it's on April 29th. I know the acting chair is going to be giving opening remarks along with Senator Warner. It's not a new issue for us, but it is our first time addressing it sort of in a workshop from this incredibly broad perspective. We've seen problems involving dark patterns in all of our work, fraud work, the privacy work, the advertising work. It's a pervasive issue. So from my perspective, anytime we're looking at something that hits, all parts of the Bureau, to me, that would fall in that bucket of sort of how are we looking at things broadly. So, we're going to look at ways in which user interfaces can have the effects of intentionally or unintentionally obscuring, subverting, impairing consumer decision-making or choice. There's some examples we've heard about and seen about sites sneaking extra items into consumers' online shopping carts, pretty egregious conduct, and other sites where you have to navigate a very complex maze of screens and confusing questions in order to avoid being charged, and a whole range of other practices covering the spectrum. So we'll be looking at sort of what is a dark pattern? How do they affect people? How does that differ from group to group? And also, just to be clear, in case it's not at all clear, if a company is using a dark pattern to deceive consumers or charge without authorization, they are violating the FTC Act. So I'm in no way suggesting that we're sort of exploring, does this violate the FTC Act? There are many, many situations where dark patterns are violating the FTC Act. So I view dark patterns, remedies, those are sort of two broad areas that we're definitely thinking of, more broadly how they impact our work.
Thanks, Daniel. On the dark patterns, is the agency doing its own research? I mean, are folks in BE doing behavioral research on these types of things, or are you sort of looking more to the academic community in the workshop to help you understand this stuff better?
At the moment, we're looking at outside parties to sort of contribute their research. And I think there's a request for comment that we just posted, I think it was last week or so, seeking sort of more concrete data and comments and information from outside parties on the issue. And I will say, I've been involved in a lot of workshops. The level of interest in this one has been really extraordinary.
Do you envision something like the .com disclosures getting revised or updated or superseded as a result of the dark patterns workshop?
I don't know if it would be superseded, but certainly, anytime we do a workshop, we want to make sure we're having deliverables. Why are we doing this workshop? What does it lead to? And certainly it is very relevant to the work that we do on .com disclosures. So to me, they would fit together pretty well as other business guidance type documents we have at the commission. So I hope we're going to learn a lot and report out what we learn as well and use it to sort of make ourselves better at what we do.
Thank you. I want to switch now to rulemaking. Chairwoman Slaughter, or Acting Chairwoman Slaughter, has indicated that she's convening a special group, I guess, within the Office of General Counsel to focus on this. Commissioner Chopra has been an advocate of additional rulemaking, both on the BCP and the BC side. Lena Khan, who's been nominated to be a commissioner, has joined him, at least on the competition side, for increased rulemaking. Can you just tell us a little bit about how BCP is involved in this effort? And I don't know if folks from your office are being detailed there, or this is a really new area. So I think people are curious as to what's going to happen.
I think information about it is going to continue to evolve and we'll continue to share information. There's not too much I can say about it at the moment, except I will say we're looking at it broadly. And certainly BCP is very involved in these discussions, and all of our divisions are thinking through, are there rules that we should be considering, that we should be exploring? Are there rules that we should be significantly changing or augmenting or getting rid of in some cases? So it's something that we are definitely looking at. I don't want to say organically, because I never really understand what that means when you look at something organically. But from the bottom to the top, we are looking and thinking about rulemaking, and are there areas that are ripe for rules at the moment? And part of this, and I'm sure we're going to talk about 13B. Part of it does certainly dovetail with 13B concerns, but obviously, the acting chairman, Commissioner Chopra, they've all been very interested in rulemaking. Before there were some of the real 13B issues that have surfaced recently. So I do think we're going to continue to see a push for rulemaking. We'll be doing it. Can't really talk about where we'll be doing it, but could be anywhere.
Sure. So one of the things I thought that was really interesting about the way that the chairwoman approached it was to create an office within the Office of General Counsel that is tasked with that.
Mhm.
Are people being, moved from the Bureau of Consumer Protection to, with subject matter expertise and, whether it's debt collection or, advertising, whatever, to work on the rulemaking, or is it all just being staffed out of the Office of General Counsel?
It's all being worked on right now. There's not much I can say beyond that.
Okay, fair enough.
Yeah.
Well, since you brought it up, 13B obviously is an issue on lots of people's minds, as I think everyone knows, but just in case, whether the FTC is entitled to equitable monetary relief under Section 13B, which authorizes it to get an injunction, is an issue that's going to get decided by the Supreme Court probably before the end of June. And I take it from your comments that the rulemaking is not just in reaction to that. It's got its own impetus, but obviously it impacts that. Is that fair?
Yeah, absolutely. I mean, it is an important case. It's a significant case for the Bureau, for the agency, for consumers also. Just to be clear, this is absolutely not just about the agency and its authority, but it's about what we can do for American consumers. And depending upon how the Supreme Court rules, our ability to get money back to consumers can be significantly hampered. Now, we are, to be clear, doing everything we can to sort of think creatively and figure out how we can plead things differently and what rules we can use in order to sort of make sure we can get monetary redress back to consumers. It's such an important part of what we do. I look at the annual redress report that we do in the Bureau, and it's hundreds of millions, if not billions of dollars that we get back to consumers some years. So the inability to do that would be, incredibly harmful. So we're doing everything we can to make sure that, if there's a rule violation that allows us to get money, we're pleading that. If there, depending on how the Supreme Court rules, if there are cases we need to bring administratively and then go Section 19 in order to invoke Section 19 remedies, we'll be doing that. But we are really looking at every case through the lens of, in the event that it's a bad decision, how do we handle this? Now, I will say, the media coverage about the oral argument was definitely one-sided. I don't think it's the case that we have no chance of winning. I don't know how much I would bet on one side versus the other. But there are decades of case law out there holding that 13B allows monetary remedies, and clearly the justices were struggling with some of the issues about the language versus the impact on the agency. It's a difficult question, and that's why they're looking at it.
No, I've got clients all the time who ask me how the case is going to come out, and I've told them that if I could predict Supreme Court outcomes with 100% outcome, I'd be talking to them from an island somewhere in the Caribbean,
yes, absolutely,
or on my boat, and I'm not. So, how does it affect your day-to-day, evaluation of settlements at all? I mean, is that factored into cases that are on potential litigation or in litigation? How does AMG factor into that litigation risk?
So look, I have yet to have an outside counsel meeting where they don't bring it up. It certainly is a constant refrain. There is a point where I'm like, okay, I know AMG is out there. Please stop talking to me about AMG. But it's not like the commission is telling me, hey, settle this on the cheap. Until the decision is made, the commission really wants us to be getting the relief that we need to get for consumers. So, for me, it's really thinking through what are the other vehicles that we have. Can we partner with state law enforcement in order to be sure that we're going to have the tools that we need? Look for those rule violations, and administrative litigation is a real issue. I do think we haven't used it that much in the past. We will be using it a lot more, probably with or without a good or bad AMG decision. But there are pros and cons to each of these approaches. I don't want to suggest that rule violations, admin litigation, it's a perfect substitute for 13B, because it isn't. Gives us some of the same tools, but they come with cons as well. You've got statute of limitations issues. You've got going administrative can be very time consuming. I think we've looked at some of the cases where we've done that, and I think from the time of filing to getting money back to consumers, it can be 7 to 10, maybe in 12 years in one case. I can't quite remember offhand the numbers, but it's an imperfect solution. And of course, working with Congress. Obviously, we're hoping Congress will implement the things.
Sure, to clarify the language in 13B, sure. In civil penalties, I mean, some of those have to go to the Justice Department. And do you envision maybe working more closely with justice in those kinds of situations? I mean, a lot of times the cases were just sort of handed over to justice and FTC. It varies considerably, but there's a lot of possibilities there.
We work really well with the Department of Justice. I will say there are people on the DOJ civil side that I've known since I started working at the FTC in 1998. We've got really strong relationships with them. We continue to work closely with them. There probably will be even more collaboration, I would imagine, because there probably will likely be more civil penalty cases. But to me, there are no issues there. It's really actually a very, very cordial, professional, and actually very supportive relationship between the FTC and DOJ that will continue.
Is there a thought to referring cases to the CFPB that involve financial products, given they have broad remedial powers, and Commissioner Chopra will be there soon, I assume. I don't know if he's actually taking anything with him, but if you do a law firm and take cases with you, you have problems sometimes.
I don't think we need to check his bag before he leaves, but
okay.
No, I mean, to me, it's an overall plus. You have good relationships with Commissioner Chopra. I think that will continue when he's over there. We collaborate really well with the CFPB in terms of who's doing what. That will continue. Maybe things may get modified a little bit, but it remains to be seen. We have frequent dialogue with the CFPB. That's going to continue, and we're very positive about continuing those relationships with them.
Great. So you mentioned a little bit about privacy, but could you give us a sense of sort of from a priority perspective, looking forward at cases, perhaps legislation, what are your and Chairwoman Slaughter's priorities, at least in the short term, for privacy and data security?
Yeah. So there's a lot that we're doing. There's a lot we're doing. There's a lot we're going to continue to do. It's going to be very active, consistent with sort of the overarching themes that I mentioned at the outset. They're very relevant actually to our privacy work. First, we're definitely looking closely at practices that impact racial minorities. We want to make sure technology is not being used to discriminate or to perpetuate discrimination based on race or other factors. And the area that we're very interested in is facial recognition technology. It obviously can serve really good purposes, but it also has the potential to be used in very troubling ways. It is not as accurate, my understanding, with respect to non-white individuals. And there have been instances of faulty matches that have led to the arrests of Black men. It's an issue that came to fruition in our Ever album case. It did not, to be clear, involve issues of discrimination, but it did involve claims that they're making about facial recognition technology. So it's an area we're very interested in, as well as other forms of AI. So definitely issues impacting racial minorities. FCRA enforcement is also particularly important given COVID issues and racial issues. Having access to housing, credit, and employment, and having that hampered by errors on your tenant screening reports or other kinds of credit reports is an area we're very interested in. We did a settlement against a company called Appfolio a few months ago. It was a $4.25 million penalty involving a tenant background screening company that had a lack of reasonable procedures, we alleged, to avoid errors in their tenant screening reports. So that's an area we'll definitely be continuing to focus on. Second big privacy area is also pandemic-related issues. There's obviously been an explosion on the use of ed tech for the last year, and it's an issue that we're studying in the context of the 6B study that is ongoing on social media and streaming services. We announced that maybe it was 5 or 6 months ago that we were doing that study, and that study is on the way. Another pandemic-related issue that we're very interested in is issues involving telehealth and health. We know that people are turning to apps and have been turning to apps to address some health issues. We brought a case flow. I made a reference to that earlier in terms of the notice provision. But this case was a period and ovulation tracker that was downloaded 100 million times. And every time I talk about the flow case, I always have to go back and make sure, 100 million, was that really accurate? And yes, 100 million times they deceptively shared health information with third parties. So that issue of privacy, telehealth, is definitely an important area that we'll be focusing on. Safety issues. We've brought a case involving stalkerware apps. We're very interested in that area. We started a 6B study on broadband privacy issues on internet service providers. We are hoping to get that study completed this year. Given the pandemic, obviously people are using their ISPs even more often than they were a few years ago. And what are they doing about privacy issues? Are they respecting your privacy? What are they collecting? Who are they sharing it with? So hopefully this year we'll be able to share some more insights on ISPs and what they're doing or not doing with consumer data. And we've got the bread and butter issues. COPPA will remain an important issue. What are companies collecting from kids that they should not be collecting? Data security as well. We've got data security matters in the pipeline, as well as issues involving ad tech. And I made an allusion earlier, mentioned these sort of remedy issues. Remedy issues are really particularly relevant in the privacy area, and that's where I definitely am seeing a sort of increased focus on the remedies. We had the Ever case involving a deletion of an algorithm. We've got Flow involving notice. So that's an area where what is the appropriate remedy in these cases will continue to be a very important issue, and I think we're going to change the landscape a bit, hopefully. And finally but not last, working closely with the Bureau of Competition. That is a recurring issue. We realize there's huge convergence on the privacy and competition side. So I think you will be seeing more collaboration between BCP and BC. We enjoy working with our colleagues in the other bureau. We did a joint workshop last year on data portability. And I think you'll see more sort of collaboration between the two bureaus. So it's something we're actually very much looking forward to.
That sounds really interesting. You mentioned 6B studies, and I think everybody who's listening knows, but if not, can you just explain what a 6B study is? And then also maybe give a little bit more color about the issues you're studying on the social media platform 6B.
Sure. So 6B is a section of the FTC Act that gives us the authority to study things, to do research, to reach out to companies, to collect data in order to issue reports to the public on what we're learning. So it's a tool that we've used in a lot of areas to sort of study markets. What are they doing? What are they not doing? And to use it as a learning opportunity. It's really an important tool for us to be able to sort of see what's happening in the market and report to American consumers about what we're learning. So we issued 6Bs to 9 of the large social media streaming platform companies. They're all 9 names that I think most people would recognize, at least 7 or 8 of them, to get a lot of information. There's a number of categories of information we're looking for. It's what are you collecting? Who are you sharing it with? What are you doing to protect the information? What are you telling consumers about what you're collecting? What obligations are you imposing on third parties? We really want to get a broader understanding of these 9 companies. What are they doing? What's going on with the data? What other sources of data are they using in conjunction with it? I will say on our website, we announced the study. We've got actually the specs, the specifications of what we're seeking are all there. But those are sort of the general issues that we're looking at. We want to be able to shine a light on these companies and this industry and what consumers can expect and what's being done with consumer data. Similar issues will be addressed in the ISP study, and that, of course, study started a couple years earlier, and we'll be able to report that out certainly a lot sooner than the social media one. But the 6B studies are a really important tool for us. It's a labor-intensive project, so it does take time to get all the data, to harmonize it, to make sure that we're not revealing confidential corporate information. It's an area we're very sensitive to. We can't really indicate company X does this. It's structured very differently to provide industry-level information. So it's a big project, but we're very excited about it and looking forward to sharing the results of both of these studies.
Sure. Is there any interaction between what the agency learns in a 6B study and the new reinvigorated rulemaking? I mean, would the 6B studies sort of be fodder or maybe an idea lab for potential rulemaking?
So, it's a good question. It is, I had not thought about that. I mean, certainly we may learn things there that will get light bulbs going off to make us think about potential rulemaking things that we should focus on. So, when we think about rulemaking, we're definitely looking at all parts of our portfolio. So, I don't think we're doing the study specifically with an eye towards rulemaking, but certainly if there's information we learn there that would help inform that, that of course is a possibility. I guess I would want to check with you. I know with our general counsel's office, but I think we are allowed to at least use the information to think creatively about broader impacts on our program, as opposed to using it for law enforcement purposes.
Sure, that's verboten. So we talked a bit about privacy. There's a lot of activity on the Hill about potential privacy legislation. Is the agency active there as far as talking to Congress, urging Congress to take certain approaches on privacy? And there's both privacy issues, there's data security issues, there's a lot going on in that space that there's always talk about giving the FTC new tools or new resources in that area. So curious your views on all that.
Tools, resources, that's all great. No, we do engage with the Hill a lot on these issues. And I'm not one to sort of predict what the Hill will or will not do, but certainly a majority of the commissioners have supported the enactment of a comprehensive privacy law for years now. And there's bipartisan support for such legislation. And certainly some of the things the commission has been frequently saying that they want to see in legislation is that we have APA rulemaking authority to allow us to sort of do appropriate rules going forward, civil penalty authority, jurisdiction over nonprofits, we think is a very important component to a privacy rule and to a data security rule as well. But you can't just do that in the vacuum. We need more resources. When you compare the number of people we have doing our privacy and data security work with foreign organizations that do similar work or comparable work, they have far more resources than we do. So certainly as Congress thinks through data security and privacy legislation, we certainly would hope that they would think through substantially more resources for the FTC so that we can implement that and do it effectively and efficiently and strongly. Looking at the bills that we see, there looks like there's a lot of bipartisan consensus around sort of substantive privacy protections around issues like accountability, transparency, access, deletion, and choice. Lots of disagreement, though, around preemption and private right of action. And I know we'll say we have not taken a position on either of those issues, so I'll avoid that next question. But I will say, it's an issue that we will continue to be very involved with. I'm really glad Congress talks to us about these issues, and I do hope that at some point in the near future we make a lot more progress on that, and something comes to fruition.
Great. So changing topics a little bit. So talking to my colleagues in anticipation of this and asked them if they had questions they wanted me to toss at you. And I've tossed a couple. And another one was remediation efforts that a company might take. So that they get a CID or they get a warning letter, that they realize there's a problem and they try to fix it. How does that effort to fix up this problem that has come to the agency's attention factor into the decision of the agency whether to bring a case, or if they're going to try and settle a case? Do you get some credit in some way for taking steps to remedy the law violation before you've heard from the FTC, or as soon as you've heard from the FTC and decide that, oh, wow, didn't know we were doing this and we need to fix it? I know it's a general question, probably a little fact specific, but we get asked this question almost every day. So I'd be curious to hear your thoughts there.
Look, from my perspective, and again, this is just me, not the commissioners, it's sorry, my phone just went off. It is relevant. It might have been Manisha Mittal telling me, like, don't say it. Actually, it was Manisha. So. It is something that is relevant, but I have yet to see a case where a company comes in and did a really good remediation. So, as soon as I hear about remediation, I want to find out more about it. Did they remediate after we sent them a CID? Maybe they knew about the problem, but it wasn't until we sent them a CID that they started to remediate. Well, that's not a great story. As soon as the company realized, we made a bad claim, something went afoul that is affecting consumers, did they quickly own up to it, publicly state it, get consumers back their money? I'm going to look at sort of, what was this remediation? Did you just post a little disclaimer on your website that a lot of people don't go to that said, hey, if you have concerns about X, click here, where there was a 0.5% uptake. Those are the kind of questions I will always ask when I hear about remediation. It's relevant, and we do want companies to be out there sort of monitoring, doing their own self-examination and fixing things. It's important, and I think it's important they have those incentives in place. And if companies are doing it well, doing it fully, not saying we're not going to bring the case, but it may impact the kind of relief we're going to seek. And certainly, if I personally, in this acting director role, see a company that has done a really good remediation, that has been transparent with consumers, that did it in a meaningful way, I have no problem, in my memo to the commission, indicating that, like, from my perspective and from staff's perspective, the company did a lot. So accordingly, we think this is the appropriate path instead of this. But when the remediation happens after you've gotten a CID and the company's already been aware of the problem, that, again, I'd rather you remediate or try to remediate than not remediate. But that is perhaps less of a plus than sort of companies doing it sua sponte as soon as they realize about it. It's interesting. I wanted to flag, there's an interesting blog that Mark Eichhorn, who's an assistant director in the privacy division, did a blog like 5 years ago, I want to say. It's called something like If the FTC Comes to Call. And it's more about the data security context. But this issue has come up in the data security context of, do we get credit if we're cooperating, if we were hacked and we're cooperating with criminal law enforcers to help find the hackers, how does the FTC view it? So it's an interesting blog, and it talks about the fact that, basically we're going to view that more favorably than a company that doesn't cooperate. Again, we can't give you sort of any absolute thumbs up, but it is something that's relevant, and we do want companies out there doing the right thing, even when the FTC isn't sort of looking through all your documents. So I do think it's an important issue, and it's something that I would certainly be very comfortable advocating that, given what the company did here, I do think we should take a somewhat, I don't want to say softer approach, but maybe a different approach. They did the right thing. They sort of owned up to it. They reached out to their customers, gave lots of money back. That resonates with me.
And I think if you look at closing letters when investigations get closed, you frequently see that one of the reasons that the commission gives for closing an investigation without taking formal law enforcement action is that the company remediated it quickly and stopped or eliminated any potential consumer harm. You agree with that?
The quickly is really important. So to me, that's a really, really big part of it. That, one of the first questions we're going to ask are sort of where are your complaints, and we've seen so many instances where companies remediate, but it's months and months after they've gotten a deluge of complaints on this issue. So that's always going to be an area where we focus on. Look, when did you learn about it, and are you listening to your complaints, and are you acting about it? Obviously, the complaints will exist that don't necessarily bear fruit, but once you get a certain number, once there's a threshold, and once your customer service people or whoever might be doing that work are sort of reaching out and saying, we've got issues, we've got to address this, that's real. So it is important that complaints are being taken seriously.
Thanks. Before I forget, let me give the CLE code word so that folks can get their CLE. It is FTC 2021. Again, FTC 2021. All right, so we've got a couple questions, but I want to just talk to you a little bit about what's life like at the FTC in the pandemic. You're obviously working from home. I'm in the office.
I'm working from home. I got my artwork behind me. Keep me company for 13 months now.
How is the bureau and both the bureau director's office, the commission, your interaction with the commissioners, your interaction with staff? How is it different? Working with everyone at home. I mean.
So I am amazed at sort of how quickly we adapted to it. I mean, it obviously happened so quickly that we all went home. And, from my perspective, I give a huge amount of credit to the Office of the Executive Director at the FTC and our information technology staff and the heads of that office, that we had the ability to do it. Candidly, if this had happened 5 years earlier, I think we would have been very differently situated. But that office has done just a tremendous amount of work to make us able to work remotely. So I've been amazed at sort of, I don't want to call it seamless, because obviously it's not seamless. I'm old school. I like paper. So for a lot of us, it has required, evolution in terms of how we do our work, and staring at computer screens for a little bit longer than we do. There obviously were real issues at the outset of courts are shutting down. How do we do depositions? We can't do immediate accesses. So there was a lot of issues in terms of things that we take for granted, the ability to file an ex parte TRO and go on site and sort of look at documents. That all changed, and we have to figure out, how does that impact us? How do we do things differently? Our litigation support people in BCP did a tremendous amount of work to help us continue to be able to review documents and get documents and have systems available. Our Consumer Response Center folks did a great amount of work to be able to work remotely, and also to constantly inform the public about the data that we were getting about COVID. So just all parts of the Bureau, all parts of the agency were creative and thoughtful. And I can't even say enough about sort of the consumer education work that was done. I mean, they were working, as far as I can tell, around the clock. And as soon as we started seeing, okay, we're now starting to get concerns about stimulus scams, that's happening. It's happened multiple times now. Let's get the messages out there. Let's get on talk shows. Let's get to the media, working with the press office. It's been, and I mentioned earlier, all hands on deck, and it's a little bit of a cliche, but it is absolutely true in terms of how the Bureau and the agency responded to it. And I have to say also, the agency and the commissioners have been incredibly supportive of staff and the ability to work from home and continue to do the work. So I have been really gobsmacked at sort of how seamless it was. I do spend a little too much time staring at my computer. So I actually try hard to sort of step away and not spend 10 hours a day staring at my screen. There are issues, and obviously there's pandemic fatigue that people are certainly going through, and our the managers of all our divisions and our regional offices have done tremendous work sort of engaging with staff and sort of making sure that communication has continued, and that when there are issues, the agency has had really robust flexibility for staff. I see lots of people with kids, but with parents issues, with friends and family members who've had COVID, and the agency has done, it makes me very proud to work for the agency, for the amount of work that we've done to support staff during this, but to also continue doing amazing work. It's been remarkable. So again, 22 years at the agency, and I'm really touched and proud of the work that we've accomplished.
You're meeting with parties on cases, I assume, correct?
Yes. Acting director does that. So
But I mean, do you find the meetings more effective, less effective, no difference when you're doing it in a format like this? I'm assuming they're happening by Zoom.
So, it's interesting. They are different. There are aspects of it that actually are great. Like, honestly, if you were here opposing counsel talking about a case, I can be getting messages right now from staff that says, "Oh, don't believe a word Len is saying." What he really So it is in person. I would not have that potential constant feedback loop, and I got that right now with staff. So from that perspective, it has made the meetings actually a little bit more helpful. But I miss the in-person stuff. I am eager to sort of get back to the office to figure out a way we can get back to work. I do think the old world is going to be different. I have to imagine there'll be more robust telework at the agency. I don't think we're going to have full-time telework forever, but others who are not me are sort of doing that assessment. I think part of why people love the FTC, why we do so well in employee viewpoint surveys is the sense of community at the agency, the ability to go next door to your colleague. Hey, I know you worked on a similar issue. Can you give me some guidance? A lot of that is happening remotely, but it is different. So I want to see folks back in the office at some point. I know it's going to be difficult. It's very hard for me to put on a shirt with buttons and a jacket right now, but Len, I'm doing it for you.
I appreciate that.
Yeah, no, I thought if I went with a t-shirt, I don't think the acting chairman would really appreciate that, and I'd probably hear about it. So actually knowing Becca, she actually would probably be slightly entertained by that. I don't wear ties to the virtual meetings, so that's another big difference. I hate wearing ties. But look, these are remarkable tools that we're using. Like, And in some ways, they do facilitate more people being involved. Like you no longer are sort of sending 5 people from California and having that cost and the expense of it, but they can pop onto a Zoom and do that for an hour and actually get back to other work right after that. So it's actually also facilitating and making it easier for some of the key people to attend these meetings. So the meetings, not just with the outside law firm, but I get to have the CEO might be there, or the CTO, or the vice president for marketing, whoever it might be. It does actually facilitate more of those kinds of discussions, which again, I enjoy dealing with opposing counsel or outside counsel. I don't usually like the word opposing counsel. But it's also really helpful to be able to hear more easily from people that work at the company. And even internally, I will say at the agency, other parts of the agency do tremendous work on different diversity events, whether it's Women's History Month, Black History Month, Pride Month. And it's so much easier to participate. We no longer have to get on the shuttle and go to the satellite building to go to these events. You go onto your computer, you pop on, you learn a lot, you sort of educate yourself, and you get back to work pretty quickly. So there are huge benefits to sort of being able to do some of this work remotely, and it's sort of increasing participation on some areas where I think it's wonderful to see more participation by staff at the agency. So it's definitely changing things, but I don't want to say it's all for the better, because again, I do like being in a room with other people once in a while.
How about with the commissioners? Is your interaction with them different given limitations?
I don't think so. They have no problem reaching out to me. In fact, maybe more often, I would guess. But they're great to deal with. They're thoughtful. They're concerned about staff as well. And they have ideas, and I get to hear about it from all of them. So it's one of the more fun and more challenging parts of the job.
Very diplomatic answer. So Daniel, you've been at the commission for 22 years. You were chief of staff to the chairman. You've been an acting director in PCP for several years. But what's surprised you about being the acting director? It's sort of, you're at the top of the pyramid now, and you don't like when you get to the top.
So, it's funny. Well, to be clear, I was chief of staff for the Bureau, not the agency. Very different job. Actually, I was chief of staff for David Vladeck. It's funny. I've gotten to work as deputy. I've worked with David Vladeck for many years. I worked with Jessica Rich. I worked with Andrew Smith. 3 incredibly different people, all wonderful to work for. That I consider myself very fortunate to work with the 3 of them. But one thing, there were times where I would wonder, wow, they work a lot. They are working around the clock. They're working every weekend. There were times I would wonder, well, do they have like poor time management skills? Like literally, the thought would pop into my head once in a while. That is not the case. Their time management skills are awesome. There's a lot to the job. There is a lot of meetings. I'm meeting with all my divisions, all the regions, all the commissioners, and keeping the work moving. So the amount of work involved is honestly staggering at times. It's great. I love the place. I have the best staff in the world. But I now understand why the bureau director often is working around the clock and can be frazzled every once in a while. But I also, I realize how important it is to have, I've got the best management team in the world, the associate directors and the regional directors, but also the folks in the front office. I've got Bureau director has to have the best deputies, and I've got Frank Gorman and Monica Baca. Couldn't do the job without them. With chief of staff Robin Moore, who has my old job that I had many years ago. The head of regional assistant director for regional operations, Rebecca Unruh. It just really drives home that it is a team job. I talk to everyone. I'm on the phone constantly all day, whether it's associate directors, my deputies, commissioners. It keeps me very busy. So when the day is over, it's like I'm for a little bit of peace and quiet. But yeah, so that's what surprised me, just how all-encompassing the job can be. I'm not complaining, because it is really an honor to do this. I never went to the FTC sort of thinking, Jody Bernstein was the bureau director when I started. Never in a million years did I think I want to have Jody Bernstein's office, but yet 22 years later, though I actually physically don't have her office, just to be clear, I've not stepped foot into Actually, I stepped foot into the office just to see, what did Andrew leave here? But but it's something I didn't expect, and it's exciting to do it. And look, whatever I can do to make sure the Bureau is in good shape for the next person. I'm looking forward to sort of stepping back into the deputy role eventually, but I'll have a newfound appreciation for what the Bureau director goes through and his or her sort of time management skills. So it's been a great opportunity, and I'm enjoying it. But it's a big job. It's a big job.
That it is. So we're just about the end of the hour. Are there things you'd like to sort of share with the audience that, takeaways that they ought to be thinking about as they think about, FTC compliance or do's and don'ts, or any sort of words of wisdom?
So, I mean, one thing I think is important, if you're coming in to meet with the commission, whether it's me, whether it's commissioners, whether it's staff, the phrase, someone mentioned this to me, and I really like it: strive for credibility. If you've got 20 arguments you want to raise, 19 of them are clunkers, but you have a really good one, really focus on the good one. I think that helps a lot, because as soon as I start hearing the clunker arguments, you sort of shut down. So I do think raise your best arguments. Nobody wants to read a 50-page white paper. So if your outside counsel is giving you a 50-page white paper, nobody wants to read it. Keep it short, make your main points. And, look, you would be, if you didn't raise AMG, that would be concerning, but we know about AMG. We know about the issues involving 13B. That really should not be the core of what you're arguing. And we get that there are potential vulnerabilities as a result of this case, but I want to hear your best arguments. And also keep in mind, when you're negotiating with staff and staff's taking positions that are, you may view them as unreasonable, they're overly burdensome, explain why they're overly burdensome. Give us concrete information. Like, we want to understand, how is this provision going to really impact the bottom line? How is it going to be detrimental to the company's ability to succeed? But also keep in mind is, when you're negotiating with staff, I've already looked at how they're going to negotiate. They've gone through me and the deputies in terms of their strategy for sort of going into negotiations. There's a really good chance I'm aware of what they're doing. Hopefully I am. And they're doing sort of what I've asked them to do. So again, when you come in to meet with me, I never want to hear staff is crazy, they're insisting X, Y, and Z, because basically you're saying I'm crazy. Again, I want to hear the real issues, like, why is it a problem? But don't make it personal. None of this has to be personal. It has to be getting to the right answer, but doing it in a way that's respectful, that's thoughtful, that's efficient. Strive for credibility. That's my mantra. I'm going to get a T-shirt that says that one of these days.
You should trademark that before it's too late.
Absolutely. I did steal it from somebody, so I should.
All right. Well,
I think it was Robin.
You can still steal it.
Robin Moore gave me that one the other day.
Okay. Great. Daniel, thank you for your time. We all appreciate how busy you are, and we appreciate your making the time for us. It's a great way to end our virtual symposium, and hopefully we'll get a chance to do this in person in the not too distant future. And again, thank you very much. We really appreciate your time. Thank you all for attending.
I'm really glad to be here. And now I get to go back to work. I don't have to walk back to my office. I'm in my office. So the world is different. Take care, everybody. Thank you so much.
All right, take care. Bye-bye.